I'm trying to get these closed a little more.
Good morning. Can everybody hear me okay?
Yes, Your Honor. Good morning.
Good morning. Thank you. Just a moment. Okay. Ms. Boulay, are you ready to go?
Good morning, Judge. Ready?
Thank you. And Ms. Kunkel?
It's Casey, but yes, I'm ready.
Thank you. Okay, we are on the record in the Colorado Public Utilities Commission's proceeding number 22R-0491 GPS. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. It is approximately now 11:35 a.m. on August 3rd, 2023. And this continued remote public comment hearing is being webcast. This third continued remote public comment hearing was scheduled in decision number R23-0453-I that issued on July 13th, 2023. The specific purpose of this continued remote public comment hearing is to allow members of the public to provide comments regarding, in particular, a new rule 11,100 subsection F proposed by the Colorado Energy Office on July 17th, 2023. With that background, I want to thank all of you for being here, for participating in this remote public comment hearing. I know it's a commitment on your part to be here, and I just want to tell you that I appreciate it and the commission appreciates it. Let me just say that in the decision I just referenced, decision number R23-0453-I that issued on July 13th, 2023, I stated that, or I provided instructions for requesting Spanish language translation of this hearing. There's a process for doing so, and there are at least a couple ways of doing it. To my knowledge, nobody has made such a request. So as a result, we have not prearranged for Spanish language translation. However, if anybody needs such translation, we can certainly attempt to provide it. However, doing so will take a bit of time to arrange. So I just wanted to give everybody that heads up. So if you need Spanish language translation, please feel free to ask. It may take a few minutes for us to get that set up. So let me just cover some of the administrative parts of this proceeding. And in particular, where I want to start is how this public comment hearing will proceed. At this remote public comment hearing, you can provide written or oral comments. Both will be given the same weight. The commission does not give any greater weight to oral or written comments. And I misspoke. Obviously, if you're here today, you're here to provide oral comments. But what I'm going to hit in just a few minutes is the process of providing written comments if you'd like. And again, let me stress, both will be given the same weight. And in fact, the commission has a preference for written comments only because many of us are clearer and more persuasive in our written communications than in our oral communications. So if you would prefer to submit written comments in this proceeding, there are three ways to submit them. One is by email sent to Dora, DORA state_PUC_website at state.co.us. Let me say that again. It's DORA_PUC_website at state.co.us. The second way you can provide written comments is through the Commission's website. The website address is puc.colorado.gov. Once you hit that landing page, you'll need to scroll down a bit until you see a box labeled File a Comment or Complaint. Once you click on that box, the page that you land on will present a form that you can fill out. And when applicable, you're going to have to input the number of this proceeding, which again is 22R-0491GPS. The last way you can provide written comments is through the old-fashioned U.S. mail, sent to 1560 Broadway, Suite 250, Denver, Colorado 80202. You can also, there's a way of providing oral comments outside of this continued public comment hearing today. And those oral comments will be transcribed and placed in writing into the file of this proceeding. If you would prefer to do that, the way it works is that you'll need to call a phone number and then leave a voicemail with your comment. That voicemail will then be transcribed and, as I said, placed into the file of this proceeding. The number to call is 303-869-3490. That's 303-869-3490. Now, with all of these options of providing comments outside of this continued remote public comment hearing, it's imperative that you include in the comments that you provide, again, the proceeding number of this proceeding. And that is, again, 22R-0491 GPS. With that information, the commission can then, the administrative folks at the commission can then place your comments in this proceeding. And as you all can guess, the commission has quite a few proceedings going on at any one time. So providing that information, identifying this particular proceeding, 22R-0491 GPS is imperative. So let me just tell you, if you're going to provide oral comments here today, and you're welcome to, let me just give you hopefully some helpful comments. First of all, change your Zoom name to your first and last name. This is important for a clear record. Use the raise hand Zoom feature to signal that you wish to speak. To do so, you need to click on the reactions button down at the bottom of your screen, and then there's a raise hand option. You just need to click on the raise hand option, and then it will indicate to me that you've raised your hand. Visually, I'll be able to see it, and then be able to call on you. If you no longer wish to speak, please lower your hand following the same process. Please remain on mute with your camera turned off until your name is called. If you do not know how to use the raise hand feature, you may instead turn on your video to signal to me that you wish to speak. To those who are participating in this hearing by phone, I'm not sure that we have any. We may have one or two. Please, you will need to dial *9 to use the raise hand Zoom feature. Please listen very carefully for your area code and the last 3 digits of your phone number. I'm going to use those numbers to identify you because that's how I see you on the screen. I only see your area code and the last 3 digits. So when I call out your number, you will need to dial *6 to unmute yourself. For everybody participating by computer, or by video, when I call your name or number, please unmute and turn on your video. And please begin your statements by stating your first and last name. And to the extent you are here representing or on behalf of an entity, please identify the entity. Now, just a few quick tips, hopefully, on presenting oral comments. When you speak, please remember that we have a court reporter who is making a transcript of everything that is said while we're on the record here today. As a result, because we have the court reporter, and so everybody can understand you, please speak slowly and clearly and try to enunciate. That will help our court reporter to get an accurate transcript. All of our statements during this remote public comment hearing need to be verbal. You cannot, well, to the extent I ask any questions of you, yes or no questions, you can't answer by shaking your head one way or the other, because that does not show up on the transcript that our court reporter is creating. Please try to avoid speaking over top of each other. At times, if I'm asking you a question, you may anticipate where I'm going, and your inclination may be to jump in before I finish my question. Please try to avoid that. Again, for purposes of the court reporter, and I will, of course, try to do the same. If anybody who precedes you in providing oral comments covers all the material that you want to cover, please feel free to just state that you adopt the oral comments presented by and then identify the person. More efficient. So let me just tell you briefly my plan. My plan is to address the Colorado Energy Office's newly proposed Rule 11,100 subsection F, and allow all of you to provide whatever comments you would like, obviously within reason, concerning that. Let me just say as well, regarding the subject matter content of this remote public comment hearing, presumably most, if not all of you, tuned into the Commissioner's weekly meeting yesterday. And you, if you did, you no doubt heard the presentation by Dr. Fischhaber that encompassed this rulemaking. Now, my understanding, based on the presentation by Deputy Director Dr. Fischhaber, is that the Commission is planning to have a stakeholder process in advance of a new rulemaking that will address advanced leak detection technology. As we all know by now, PHMSA has just started its own rulemaking addressing advanced leak detection technology. That rulemaking is in the early stages. I've heard different things from some of you in terms of predictions of when that rulemaking could end, but it's going to be an ongoing process for some time. And the results of that process, ongoing, and of course at the end of the process, will be of high value to both you, the participants, and the Commission in formulating the Commission's approach to advanced leak detection technology. As a result, and then that the Commission is planning on a new rulemaking on advanced leak detection technology, I do not plan to include, I do not plan to address advanced leak detection technology today. I'm not planning on including rules addressing advanced leak detection technology in this proceeding, in light of what we were all told yesterday by Dr. Fischhaber. With that, let me open up the floor and just see if anybody has anything they'd like to say at this point before we jump into proposed rule 11,100F as proposed by the Colorado Energy Office, who I'm going to refer to as CEO throughout this proceeding. So, does anybody have anything they'd like to say at this point? And I'm not seeing any hands go up. So let me just jump right in. I'm presuming, well, first of all, let me just ask, I see that Representative Story is here again today. And again, given that, I'm sure her time is very valuable. Representative Story, if there's comments that you would like to make to start us off, I'm certainly willing to listen.
Thank you,
Welcome.
Judge Farley. Can you hear me?
I can, thank you.
Okay. Sometimes the audio on my end when you were speaking was sort of coming and going, which might mean that it's on my end. So please let me know if I'm not coming across well, and maybe I'll sign off and sign back on. I appreciate the opportunity to.
And I'll tell you, Representative Story. But let me just say briefly that for me anyway, you did just cut out and freeze momentarily during what you just said.
Okay.
And I don't know if that's a problem on my end.
Well, I think I'll just sign off for a minute and get back on and see if it improves any.
Okay.
So I'll be back
That sounds
shortly.
good. While you're doing that, thank you. I'm going to check on my end to see if I can see any issues. So look forward to seeing you back.
Judge, my computer is telling me that your bandwidth is low.
That my bandwidth is low?
Yes.
Okay. All right. Give me a moment.
Your Honor, I was going to say you are cutting out a little bit for me as well.
Okay. So let's go off the record.
You've been perfectly clear on my computer. Just devil's advocate, but it's been fun for me.
Thank you. So I tell you what I'm going to do is I'm going to sign off as well and get back on. And hopefully I may also restart my router. So I'll be back as soon as I can in trying to fix this issue. So thank you. I'll be back.
For anyone who's just joining us, Judge Farley is having some issues on his end as well, so he's signing out and rejoining and be back in a few minutes.
All right, so I am back. Can everybody hear me okay now?
Yes, we can hear you.
Okay. If the problem continues, please feel free, please do interrupt me and let me know. And there's at least one other thing I can do if the problem's on my end. So anyway, I apologize for that. Let's go back on the record. And Representative Story, I think maybe you were about to say something.
Okay, so yes, if you're ready, I'm happy to share some remarks.
Yes, please go right ahead.
So first of all, thanks again, Judge Farley. Good morning. I appreciate the opportunity to address you today and those who are also signed in online, listening as well. My name is Tammy Story. I'm a state representative for House District 25 in Jefferson County. I wish to provide what I hope to be closing remarks concerning the rulemaking process for Senate Bill 21-108, for which I am the prime sponsor for this Senate bill in 2021. Time is of the essence. My legislative work focusing on pipeline safety has made it abundantly clear that public safety has not been adequately prioritized when it comes to adherence to federal and state laws and regulations. Over time, I have observed extreme deficiencies in the installation of pipeline infrastructure. I've heard from numerous natural gas customers of their concerns for the status of natural gas lines servicing their homes. Many have subsequently filed complaints with utilities and the PUC, only to have them go unanswered for years or remain unanswered still. Customers have shared that their lines have not been leak surveyed, even when contractors have been in the community to do so. I was told by a utility that during one summer season, 50% of the utility's district was appropriately surveyed, and there were no leaks. Not one, no leaks. I worked for a leak detection company during 2 summers, and every day I was in the field, I found leaks on meters, on service lines, and on main lines. It is unfathomable that a utilities district supposedly surveyed comprehensively would yield 0 leaks. All of these scenarios are deeply unsettling to me. My efforts led me to requesting the performance audit of the pipeline safety program, specifically to address processes and procedures as they relate to the oversight provided by the PUC. Given what I had already learned, I expected there to be findings. I had no idea the scope of the systemic issues were for all of Colorado. The performance audit of the natural gas pipeline safety program is nothing short of scathing. No element researched by the Office of the State Auditor meets acceptable standards of compliance. Now, 2 years after Senate Bill 21-108 was signed into law, rulemaking is underway. Given my own insights and the revelations of the performance audit on the natural gas pipeline program, the elements being considered by rulemaking must be addressed with a laser focus on public safety, adherence to federal and state laws and regulations, and rigorous, timely implementation. 3 elements were on the list to be considered for this rulemaking: mapping, reporting of leaks, and advanced leak detection systems. I understand from what you said just moments ago, Judge Farley, that you will no longer be considering the leak detection systems in your efforts for this rulemaking process. Nonetheless, I'm going to share some insight on that element anyway. I discussed mapping during the June 29th hearing. The language within Senate Bill 21-108 requiring that all pipelines within the jurisdiction of the PUC are mapped, and for those maps to be publicly shared at a 1 to 6,000 scale is clearly stated in the law. The law also states the Public Utilities Commission's mapping requirements for pipelines within its jurisdiction must incorporate the same standard for confidentiality, security, and public access, and limitations on the scale of publicly available images as adopted by the Oil and Gas Conservation Commission, now the Colorado Energy and Carbon Management Commission, known as the ECMC. Giving local governments access to maps and data at a scale of 1 to 6,000, along with confidentiality standards, the same as is applied for the ECMC, is not a matter of debate. The language in the law is unambiguous on the matter of mapping. Reporting of pipeline leaks is very crucial. Every leak identified should be documented, reported, and fixed. Allowing leaks to go undetected, undocumented, unreported, and not fixed is unacceptable. Pipeline leaks are a public safety hazard and are a threat to the environment, increasing carbon emissions and exacerbating climate change. Pipeline leaks are an obvious loss of revenue to the utilities and result in increased costs to customers. The comprehensive reporting of all leaks will provide data that is necessary for the pipeline safety program to function as is required to assess risk, prioritize inspections, and evaluate operators. All of these elements are identified as deficiencies in the performance audit. The advanced leak detection systems are a newer technology that will aid in identifying leaks, a crucial element to pipeline safety and integrity management. It would be negligent to delay the adoption of this technology, given the glaring deficiencies outlined in the performance audit that is focused on significant deficiencies in inspections, documentation, reporting, assessed penalties, and fixing pipelines. The use of advanced leak detection systems should be implemented immediately to address the shameful practices that have been identified since 2017. When PHMSA regulations are implemented for advanced leak detection systems, then Colorado can be nimble enough to address any updates required. Coloradans shouldn't have been subjected since 2017, and likely much longer, to the grossly deficient processes and procedures of the PUC's pipeline safety program, or by the utilities, as identified in the performance audit by the Office of the State Auditor on the gas pipeline safety program. The urgency of this situation cannot be overstated. Unnecessary environmental hazards persist and public safety is at risk, which should be dramatically improved by addressing the rulemaking for mapping, leaks, and advanced leak detection systems to be as stringent and productive as possible. This is not the time for compromise. Colorado deserves a pipeline system that prioritizes public safety and the protection of the environment. And thank you so much for your time.
Thank you, Representative Story. Let me just ask you, I think, one question, but I can't promise that. So others here, principally, at least, I'd say Atmos and Black Hills, regarding the mapping requirement, have argued that the commission has discretion essentially over what to include in what's disclosed at the 1 to 6,000 scale. In other words, what they're suggesting, I think piggybacking on an idea that perhaps I first floated in the last hearing of limiting the amount of information publicly available at the 1 to 6,000 scale. And when I've talked about that, I've kind of talked about that as a potential compromise between the public's need for information regarding pipelines and where they are, and perhaps their proximity to property that they own, versus the security issues that have animated a lot of the discussion here. In other words, not wanting to effectively provide a roadmap to people with bad intentions for what infrastructure is the most important, and or if targeted could maximize damage. And I'm just wondering if you have reaction, any thoughts about that?
I am not blind to the issue of that has been shared, or the concern that's been shared, where people feel that it makes the system less secure to have mapping available to the public. But that's why the scale is what it is. And the ECMC, or then the COGCC, did adopt that same scale for the pipelines over which they have jurisdiction. And I feel that if that scale was acceptable and workable at that time for the COGCC, I see no reason why the same scale can't also be utilized so that the maps can be married and utilized together to make sense of the system that we have without compromising security, where people can't zoom in for a closer look any closer than the 1 to 6,000 scale that has been presented. I think there are people out there with all kinds of nefarious intentions for all kinds of different possibilities beyond pipelines. We will never be able to eliminate all of those risks. There are plenty of opportunities right now, even without the mapping, where people, have access to pipelines and infrastructure that is much more significant than our main lines running through communities and service lines running to residents and to businesses. So again, I hear that concern, but I think given the circumstances where we are and the need for access to mapping for local government, that I think this will be beneficial and allow them to do a better job within their communities, knowing where pipelines are. And it also is at a scale that preserves and protects the public as would be necessary.
Okay. Thank you, Representative Story. I very much appreciate your comments today, as well as your comments from the last remote public comment hearing. So thank you.
Thank you.
And sorry, I'm getting an indication that my internet connection is unstable again. If anybody, please let me know if if you're having trouble hearing me or understanding me. So with that, obviously, Representative Story, you're welcome to stay. If you have anything further at this point, feel free.
Thank you. No, I'm finished at this point, but I will listen as long as I can. And I appreciate the opportunity again. I'm sure there are others that wish to speak as well.
Yes, understood. Okay, so let me move on. And again, I'm focusing on CEO's proposed map rule of 11,100F. So let me just ask CEO, I think I saw Miss Lowry here previously. Welcome. It's good to see you. Okay, let me just ask a couple of questions, at least a couple of questions. Again, I can't promise that it will only be two. But so, I mean, the proposed rule, at least the beginning of it, as proposed by CEO, I'll just read the first part of it into the record. Any operator that is an investor-owned gas utility must provide in a gas infrastructure plan or is otherwise directed by the commission a map showing system-wide locations, ages, and materials or types of distribution system pipes. And I think, although I can be obviously corrected if I'm wrong, at least a couple of the investor-owned utilities, not only in the most recent round of comments in response to CEO's proposal, but in previous public comment hearings, have basically said, they don't have all this information. At least not for mapping purposes and being able to identify, pipe on a map and being able to provide the information that's proposed in this rule. And I know that public service, I think, took issue a bit with one or more statements made in CEO's comments proposing this rule about this information already being provided to PHMSA pursuant to PHMSA's reporting requirements. I guess my first question, Ms. Lowry, is, do you agree with what I think it was Public Service said in their most recent comments regarding that issue, specifically the fact, their contention that they don't have all this information and that PHMSA does not require them to have all of this information, at least not at this time?
Thank you, Your Honor. Good to see you too. Jessica Lowry, Second Assistant Attorney General representing the Colorado Energy Office, and Keith Hay, Senior Director of Policy for the Colorado Energy Office, is here as well. To your first question about whether the utilities have this information, I don't know whether they have it. I don't know whether they can get it. Maybe they have it and they haven't compiled it, or they don't have it in a mapping form. We certainly hope that they have this information about their system. And, fundamentally from CEO's perspective, this is a statutory requirement. And so the utilities need to get this information and provide it in a map. And so it's not optional. And whether it is required by PHMSA, it was my understanding that this information is required by PHMSA, but I don't have a true knowledge of what is required and whether what Public Service said was true.
Okay, thank you.
Requirements. Yeah.
Understood. And Mr. Hay, you popped up. Do you have anything to add to this? And I'll just pose the question. Let's assume for a moment, and Mr. Denman can weigh in after this. Let's assume for a moment that at least not all of the investor-owned utilities have all of this information in a way that could be, put into GIS data and used in a mapping or in a map utility. So let's assume that's correct. I think we've heard at least suggestions in previous public comment hearings that it would be expensive and time consuming for the investor-owned utilities to obtain all this information to be able to, use it in a map. So I guess the ultimate question is, should the commission impose this requirement on the investor-owned utilities, no matter the cost, and just tell them to get on it and get it done? Or should cost be an issue?
Before Mr. Hay speaks, if I could just respond, that I'm not sure it needs to be in a GIS map. It needs to be a map, and so it could be a PDF. It just needs to be a map where we can see the location of these pipes in order to then help determine in these gas infrastructure plans and clean heat plans, what upgrades are needed for the system, and help the commission and parties evaluate the utilities' claims of infrastructure upgrade needs. I'll let Mr. Hay talk to the cost recovery perspective, but it's our position that, first of all, the cost recovery does not need to be in the rules. That should be addressed in separate utility proceedings, whether it's a clean heat plan or a rate case. And that, of course, costs matter, but there's probably some less expensive and more expensive ways to provide maps. And so I don't know that there's a one size fits all for that.
Thank you,
Okay,
Your Honor. If I may add just briefly.
Yeah.
I don't believe, as Ms. Lowry said, that the commission here is imposing anything on the utilities. I think the General Assembly has given clear guidance about what the utilities are required to do. We think that this is a requirement on all of the jurisdictional utilities, and therefore it makes sense to include it in rules that would be generally applicable to the utilities. I understand the concern about the potential costs. That's not something that the legislation itself speaks to. Were this implemented in rule and not otherwise a statutory requirement, the utilities might be able to seek a waiver of the particular rule, or at least appeal to the commission based on the cost of implementation. So, again, in our view, this really is a statutory requirement. I think the question is whether or not the commission wishes in this instance to put it in rule or simply let the statute stand. And we've taken a clear position on that question, Your Honor.
And your position is clearly that you think it should be reflected in the commission's rules.
We do, Your Honor. Thank you.
Okay. So let me just ask, the first sentence of the rule that you proposed, 11-100F, I think I've already read it in the record, but I'll do it again. Any operator that is an investor-owned gas utility must provide in a gas infrastructure plan or is otherwise directed by the commission a map showing system-wide locations, ages, and materials or types of distribution system pipes. So the way I interpret that is that, but you correct me if I'm wrong. Maybe I don't understand this correctly. So you'd have a map, you'd be able to zoom in on particular locations, particular sections of a pipeline, and that for that section, there would be related information regarding the age and material of that section of pipe. Do I understand that correctly? Is that the intent of what you've proposed?
I believe so, but Mr. Hay can elaborate if he has a different idea.
Thank you, Your Honor. Thank you, Ms. Lowry. As Ms. Lowry suggested, that there are more and less expensive and inexpensive ways to likely approach this problem of providing mapping. I think the way we have thought of this is less about the particular technology involved and more on the outcome that we hope to be able to achieve, and that is to have information about the utilities distribution system that can be used by the commission and other interveners to understand what pieces of the system are likely to need upgrades or investment over what periods of time, and to be able to overlay that with other types of information that we may have access to, whether that's using the database at the Colorado Department of Public Health and Environment to identify historically and disproportionately impacted communities, or other types of information that other interveners may want to bring to the table. Right now, we at the Energy Office, other interveners in the commission are somewhat blind to the scope and scale of the utilities gas infrastructure. And so would it be beneficial to have an interactive, usable map? Perhaps, though I think that certainly raises a lot of questions about the security and the safety of that. Would it be reasonable to start with a PDF version of a map that provides that level of detail, but that's visual in nature? Probably. And so I think we would be open to the particular technology, but it's really the focus on that outcome, I think, that has been driving our interest in this mapping.
Okay. Let me turn quickly to Mr. Denman and see whether I've gotten correct what I think I read in Public Service's latest round of comments. Mr. Denman, my recollection is that Public Service said in that latest round that this level of information, degree of information, is not required to be reported by PHMSA at this time. In other words, I think what Public Service has said is essentially Public Service doesn't have, for example, age and material of all the pipe in its system, at least not in a way that could be easily incorporated into a report. Do I have this right?
Yes, you do, Your Honor. For the record, Stephen H. Denman for Public Service.net, Colorado. I have with me here today Mr. Mark Nolan, who's my subject matter expert on all these things, and he might be able to elaborate to help answer Your Honor's question. You have read our July 27th comments correctly. And in section 49 CFR 191.11, and then in the instructions for the DOT annual report form F7100.1-1 is where you can find the material that we discussed on page 11 of our comments. And PHMSA does not require you to report data that you don't have. And as to the cost, I can appreciate Ms. Lowry's comments that the rules in this case shouldn't address cost recovery of GIS mapping, but and regarding the comment that it doesn't need to be in GIS form or GIS form, it can be a PDF. Where we started was with the commission's noticed rules, and in proposed rule 11-100, particularly in subsection C, the commission started off requiring this to be GIS data. And so the approach we've had is what we can do and what we can provide compared to what PHMSA requires for the National Pipe Mapping System, and what we can provide. And so that's the approach we took, because that's where the commission started. Whether there's some easier, cheaper way to do it is perhaps something that could be explored, but it's not in this rulemaking. And, we've explained in our comments why we believe this mapping requirement for gas infrastructure planning in Senate Bill 23-291 is self-executing. You really don't need to adopt this rule proposed by the Colorado Energy Office in order for them to get what they have been trying to get for a few years regarding gas infrastructure planning maps. And so I'll turn over to Mr. Nolan if he has any additional information to provide you on.
So welcome again, Mr. Nolan, and I think we've covered this in great depth in our previous remote public comment hearings. So, I mean, my understanding of public services position is essentially that public service has some detailed information regarding its pipelines, maybe a lot, but it has some, but there are gaps. The gaps consist of, I think, information that public service has, but it's in written form, in records, that would take a fair amount of time for public service to basically go through to extract for purposes of including it in a map like is being proposed. And then there's another category of information that public service just doesn't have at the current time. Are those three buckets that I think we've covered? I won't say ad nauseum, but covered in previous public comment hearings, Mr. Nolan? And you are muted, Mr. Nolan.
Thank you. Good afternoon, Judge Farley. And yes, this is Mark Nolan with Public Service Company of Colorado. And primarily what we wanted to clarify with respect to CEO's comments, it seemed like they were implying that all of this information they're requesting is already required under the PHMSA annual reporting requirements and or the PHMSA distribution integrity management plan rules. And we just wanted to point out that with the reporting, the report does indeed ask for aggregate mileage of pipe by material type and also aggregate mileage by the decade of installation. However, there's clearly columns for unknown where a utility may not have that information. And in the case of most operators, I would assume that we have the majority of the information and certainly the newer information in our GIS systems. But with older records, we may not have the records or the records may not be in digitally retrievable format. With respect to the distribution integrity management rules, which were also cited in CEO's comments, it's true for newly installed pipe, we need to capture certain information. And it's also true the rule requires us to retain any pre-existing information we may have. And it's certainly in our interest to collect and retain as much as we can for the purpose of complying with those rules. But again, we do not have all of it, and the rules don't require us to retroactively dig up the pipe to determine pipe properties. Thank you.
Okay, thank you, Mr. Nolan. So, Ms. Lowry, Mr. Hay, I'll give you an opportunity to respond, but let me just pose another question for you, which is many of the entities that filed comments in response to your comments and proposal have raised a notice issue. In other words, did the notice of proposed rulemaking provide sufficient notice to the public of this type of change? And one or more of the commenters have made the point that Senate Bill 23-291, which is the basis, I believe, for the change that you've proposed, was not, well, certainly had not been signed by Governor Polis before the notice of proposed rulemaking. Therefore, how could the NOPR, as we call it, have provided notice of this kind of change? So I just wanted to give you the opportunity to respond to that, since you have not had an opportunity to date.
Sure. Thank you, Judge Farley. It's CEO's perspective that there is not a notice problem, because this rulemaking was open to be a rulemaking addressing gas system maps. And we are asking for a rule that requires gas system maps. And so we believe any entity that would be interested in gas system maps has already had notice of this rulemaking. And I believe the commission itself was under that impression when it directed CEO to bring our mapping request into this rulemaking. This rulemaking had already been opened when the commission issued its decision directing us to bring our comments here. And the other point I want to make is that all of the gas utilities that would be subject to the rule that CEO is providing are here in this rulemaking and have had an opportunity to comment. So we don't believe there would be any notice issues with CEO's proposed rule.
Okay. And I believe in your comments, you anticipated this this argument, Ms. Lowry, and I believe that the parts of the NOPR that reference mapping are included in your comments. Is that correct?
Yeah, I believe so. I was scanning quickly to find that, but I do remember writing that.
Okay.
I couldn't tell you the page number right now.
Okay. Well, obviously, if you want to supplement this argument, if you continue looking, you'll be given the opportunity. But I'm just trying to identify. Yeah, you've made this argument in your comments, so I think that's the best source for me to consult in completely understanding it. So, Mr. Denman has raised his hand, or I see Mr. Hay, you're still up. Is there anything that you wanted to say on this, Mr. Hay?
Thank you, Your Honor. I think I would just for a moment like to respond to the concerns around what information the utilities have in what format and what's in our view being directed to be provided. I think the way we have understood the statute as we have tried to ask for its implementation here, is that it would provide a map. We understand that the utilities may not have all of the information that we think the statute requires in a map format currently, and understand that it would require some amount of work on behalf of each of the utilities to take that information and begin to map it. It's also clear from what has been filed here that some of the utilities may lack certain pieces of information or may lack it in an easily accessible digital format. With respect to the latter of those things, I think while it may be work to begin to put that into a format, I think that at the end of the day, there is value to the commission and to stakeholders to have that information. Again, this isn't a request that CEO is making because we have some desire to drive the utilities to do work. We see value to the commission and to interveners in proceedings as we go forward looking at the gas system that we have this information. It's reasonable to think that it could be iterative. To the extent that there are, sections of utility system that predate record keeping in any accessible format, I suppose the utilities could simply identify that, and that might tell us roughly when that pipe was installed. I mean, it's sort of, jokingly, I mean, maybe we have a map that says there be dragons on the edge of it or something, but, it gives us a sense at least that that's old enough that we don't know when it was put there. We don't have records of it. And if that's the case, then again, that's information that's valuable to the commission and to parties.
Understood, and I appreciate that, Mr. Hay. And I don't think, I mean, let me assure you that I am not, and I'm certain the commission is not underestimating the value of this information. Our role as always is to do what's in the public interest, and imposing an obligation on the investor-owned utilities that they can only comply with over the short term by spending way more money than ratepayers are able to pay through rates is something that we need to consider. So that's why I'm raising these questions and just trying to understand CEO's position, but also what the state of the information is that utilities have, and try to ensure that through rules, to the extent they're implemented, we're not imposing obligations that are contrary to at least the short-term public interest because of the cost involved. So I just want to assure you of that, what my thinking is on this, and I'm sure what the commission's thinking is as well. Thank you for your comments, Mr. Hay and Ms. Lowry. I'll have more questions for you. Mr. Denman had his hand up. Mr. Denman, do you want to weigh in here?
Yes, Your Honor. Thank you very much. First of all, let me say that I'm glad you appreciate the cost recovery problem. And while I agreed with Ms. Lowry that shouldn't be in these gas pipeline safety rules, it is the 800-pound gorilla in the room, perhaps. And while it's true that cost recovery issues come up in an appropriate rate case, it's still a problem if, in the example Your Honor gave, that we and other utilities would have to spend millions to try to ferret out the information that we don't have in a format that might eventually be required by the rule. And I've been a litigator for a long time, and we used to always call this problem the blood out of a stone. In other words, you can't get blood out of a stone, and if somebody simply doesn't have the information, and it's going to cost millions to force them to gather it together, that's not sound, prudent regulation. And secondly, I'll point out that I truly sympathize with Ms. Lowry's dilemma. In the gas infrastructure planning rulemaking, as we discussed in our comments, CEO attempted to get what I'll call their GIP mapping details into those rules, and the commission denied that in the initial decision. And then on rehearing, they did say that, and this is in the rehearing decision in that rulemaking, CEO or others may consider providing relevant comments in the pipeline docket 22R-0491GPS. And that's true. I will submit that may consider doesn't amount to a direction for CEO to jump into this rulemaking and once again propose their gas infrastructure planning mapping rule into this gas pipeline safety rulemaking. And as I listen to the comments of my colleagues from CEO today, they're talking about gas system planning. And that is simply not the intent of this rulemaking. I understand their notice argument. I have been through these arguments many times. And the lesson I always learned is you have to look carefully at the requirements of the Administrative Procedure Act and at the notice of proposed rulemaking issued by the agency. And in our comments, we carefully went through the NOPR and what we discerned to be the intent. They may have mentioned the word mapping in there once, and the rules under Senate Bill 21-108 do have a mapping requirement for gas pipeline safety. But the problem is this rulemaking is not about gas infrastructure planning. And as we said, the Senate Bill 23-291 mapping provision is self-executing. And finally, it seems that the language of the APA and this commission's NOPR, we believe, made it very clear what this rulemaking is supposed to be about. And it's up to the commission to decide whether or not they believe the GIP mapping data requirement that CEO proposes is within the notice and scope of the rulemaking. The other, well, I have other comments about another part of their rule that I'll hold until later. The first part in subsection F, all of that material is in Senate Bill 23-291. You don't need this rule and this rulemaking, Your Honor. Thank you.
Thank you. Along those lines, let me ask you, Ms. Lowry, I mean, does this proposed rule 11100F, is it just the language from the Senate bill that Mr. Denman just referenced? Is it word for word?
I largely tried to pull from the Senate bill language as much as possible, with trying to keep it in rule language. And I would just say that the reason that CEO believes that it should be adopted in rules is because I'm not sure it's clear. I'm not sure the utilities, maybe public service understands that it's required, but based on the comments from the other utilities, I'm not sure they understand it's required. I took their comments to continue to argue about whether these mapping requirements were requirements, whether the commission had discretion about requiring utilities to provide these maps. And so CEO believes it would be clearer if these could be included in rules, but we agree with Mr. Denman that even if these requirements are not in PUC rules, the utilities are still required to comply with the statute.
Okay. Mr. Stoffel just raised his hand. You may go ahead, Mr. Stoffel.
Thank you, Judge Farley. Good afternoon. I just wanted to add or respond to what Ms. Lowry just said. And we agree that the requirements for the gas infrastructure plan mapping are self-effectuating, that an implementing rule is not necessary. But I think the important distinction that it highlights is the mapping requirements for this pipeline safety rulemaking applicable to pipeline operators under the commission's jurisdiction are different than the rules applicable to gas utilities under the commission's gas infrastructure planning rules. And in fact, the pipeline safety rules and gas rules are entirely separate now. And so that was part of the comments we filed, that we recognize this requirement for the JIPs, but it'd be inappropriate to put it into the pipeline safety rules that apply to more than just the gas utilities.
Okay. Understood, Mr. Stoffel. I appreciate that. Let me just pose the question raised essentially by what Ms. Lowry said. Is there anybody here who believes, the language in Senate Bill 23-291 that led to this proposed language from CEO is not self-effectuating or otherwise a requirement imposed on investor-owned gas utilities? Okay, I'm not seeing anybody come forward. Okay. All right. So, give me just a moment. All right, Miss Lowry, at least one more question for you. So this as well was in Senate Bill 23-291. It's the amendment to section 40-3.2-104.4, subsection, I think it's 3C. And this is the subsection, I'll just read it into the record. The commission, referring to the Public Utilities Commission, shall ensure that the content of the map provided to the commission and sharing procedures are in compliance with the parameters related to critical infrastructure reporting standards of the California Institute for Energy and Environment or its successor organization, and the safety and system integrity standards of the American Petroleum Institute or its successor organization. I'm sure you're familiar with that. Is that right, Ms. Lowry?
Yes, I'm familiar with that part of the statute.
Okay. So these standards, so one is from the California Institute for Energy and Environment. The other is from the American Petroleum Institute. I don't think they're a part of this record. Am I correct about that? And I also think Public Services basically said they've looked for them. They made a diligent search, I think. Language along those lines, and they haven't been able to find them just generally. In other words, not just focusing on this record. So, so first of all, are those standards a part of this record?
No, Your Honor, they are not. PEO could not find them either. We were able to find those two organizations, but we couldn't find the standards referenced in the statute. And the Energy Office has checked with the bill sponsor, and he doesn't know where they're located either. So I think the statute is quite confusing on that point.
Okay. All right. So I see Alejandra Major has raised a hand. Hello and welcome.
Hi, Your Honor. Yes, I'm with the American Petroleum Institute, and if there's an issue with getting standards from API, I would be happy to do that and provide that for CEO.
Okay. Are you familiar with whether API, the American Petroleum Institute, has safety and system integrity standards that would apply to what's referenced? I just read it into the record.
I believe that we do, yes.
Okay. All right. Well, that would be helpful. So thank you for offering that. Okay. Mr. Denman, I see that you just turned on your video. Do you have something you'd like to say here?
Yes, Your Honor. It's hard for me to find the raise and lower hand button. The problem isn't so much whether you can find these standards, and I appreciate that Ms. Lowry couldn't find them either. We've had several people in our organization trying to find those standards cited in the statute. The problem is found in the Elizondo case, which we cited in our comments. The Colorado Supreme Court's made it clear if an agency adopts a rule that has no standards or no discernible standards, I would say the same thing goes for a statute. There's a serious constitutional problem with that section of the statute. Now, I can appreciate the limits of the commission's authority about deciding whether or not one of its organic statutes is constitutional or not, but I merely suggest that that's an issue that you and the commission should keep in mind regarding anything to do with these so-called standards that even my colleague Ms. Lowry couldn't find. That's all I wanted to suggest.
Okay, thank you, Mr. Denman. So at this point, I think I'm ready to move on. I have a few other areas related to this, basically, proposals made by commenters in the latest round of comments that CEO, for one, has not had the opportunity to respond to, that I'd like to address. But before I do move on, I mean, does anybody have any further comments regarding CEO's proposed map rule 11-100 subsection F? Okay. All right.
Your Honor, my apologies, I wasn't quick on the button there. The only thing I would add, and I don't believe we put this in our comments, in the subsection FI, particularly the last sentence, regarding critical infrastructure information, we have suggested that part of Senate Bill 23-291 is also self-executing, but if you're inclined to adopt CEO's proposed rule, that last sentence, I believe, is problematic. Rule 1101B of the Commission's Rules of Practice and Procedure allows anyone who believes they've provided highly confidential material or asking to be providing that material and file a motion for extraordinary confidentiality protection, which for short I'll call a highly confidential protective order. And that rule 1101B does not impose any restrictions or exceptions to whom that extra confidential protection must be given. This proposed rule would carve out an exception that doesn't appear in Rule 1101B or any of the Commission's confidentiality rules. So I suggest that warrants extra scrutiny from Your Honor. And subject to the approved non-disclosure agreement could be problematic because there are, with the exception of the staff, ALJs, the commissioners, and perhaps the UCA, there are no approved non-disclosure agreements. And in the case of highly confidential information, the motion for extraordinary confidential protection always includes a tailored non-disclosure agreement to protect that information and within the limits of the Commission's determination of who gets access to highly confidential information. And it's always been the Commission's practice that in motions for highly confidential protection, the Commission has discretion as the trier of fact, and this is one of the Commission's inherent powers under Article 25 of the Constitution to decide who gets access. First of all, they decide whether or not the information is highly confidential, and then they decide who gets access, and they try to balance the case-by-case necessity of each of those cases in which such a motion is had. And it occurred to me that this one sentence interferes with the Commission's discretion. And I haven't thought a whole lot beyond what I've just said about this, but I would suggest that you carefully scrutinize all the ramifications of that sentence if you're inclined to adopt this rule.
Thank you, Mr. Denman. Let me just make sure I understand this. So in that last sentence, starting that, except that any critical infrastructure information basically says that this critical infrastructure information provided highly confidential protection. And now I'm quoting, must be available to all state agencies that are interveners in the proceeding, subject to the approved non-disclosure agreement, end quote. Is that what you mean by it's taking away discretion from the commission because it's specifying who must have access to the information?
Yes, Your Honor. I mean, this limits the commission's sound discretion in deciding who gets the access to highly confidential information. And typically, whether it's a state agency or another intervener, is something that's worked out in every case on a case-by-case basis based upon whatever circumstances exist and who those folks are in the case. That was just a reflection I had when I read this rule again yesterday. So I thought I would mention it for Your Honor's consideration.
Okay.
Thank you.
And it does. I'm just looking at Senate Bill 23-291 to see whether this language in CEO's proposed rule was taken from that Senate bill.
Your Honor, may I respond?
Go ahead, Ms. Lowry.
Thank you. That language was not taken from the Senate bill. The Senate bill discusses how the commission needs to make a determination. If a utility believes that any information in the map constitutes critical infrastructure information, the commission needs to make a determination about who should have access to that information. And then the Senate bill says, and this is under subparagraph, so it's 40-3.2-104.4, paragraph 3, D, Roman numeral 2, A.
I'm there with you.
Yeah, so it says if the commission determines that the disclosure of the designated map or associated information may expose or create vulnerability to critical infrastructure, facilities, or systems, the commission shall limit access to the designated map or associated information to individuals at state agencies that are parties to the proceeding in which the map or associated information was provided. And then it goes on to discuss how the map should not be provided to any persons. Well, I'm not going to read that part unless you want me to.
That's
but
okay.
The main
I see
point
where you are.
that, yeah, the statute is saying that even if the commission limits public dissemination of the map, that the state agencies need to be given access. And so that would include, and that's where we got the sentence in our proposed rule. So while I agree with Mr. Denman that the proposed rule might limit the discretion of the commission in who it allows to access the map, the statute provides that these maps need to be accessible to state agencies. The other thing I wanted to respond to is just to note that we added that language about using the commission's confidentiality rules to, determine whether there's critical infrastructure information and to limit through NDAs that were approved by the commission, because the statute itself doesn't provide any specific process, and we believe that the commission's already established confidentiality rules could be used for that process. And to Mr. Farley or Mr. Denman's concern that last sentence says subject to in CEO's proposed rule says subject to the approved non-disclosure agreement, I agree that the commission always approves individual, highly confidential non-disclosure agreements whenever it grants a motion for extraordinary protection. So this sentence was intended to reference the non-disclosure agreement that was approved by the commission in that instance. So I apologize if that last phrase was confusing.
Understood. Thank you for that clarification, Ms. Lowry. Mr. Denman, do you have something brief? Mr. Head has had his hand up for a while and I want to get to him, but if you have something in response, go ahead.
Yeah, I appreciate Ms. Lowry's comments. When I read the statute, I thought that section that we've been discussing might have been the source of that, but it appeared to me that that statute could limit the commission's ability to let anybody else in that litigated proceeding who may be an intervener have access to that confidential or highly confidential information other than state agencies. But I would suggest also that the term critical infrastructure facilities is a term of art in the electric industry. And when we said in our comments filed July 27th that we weren't sure whether this part of the statute applied to natural gas operations, we weren't sure what it meant, and it's not defined in the statute. And so we have always understood, based largely on FERC regulation, that critical infrastructure facilities is a term of art in the electric industry, not the gas industry. And so that ambiguity of the statute makes us wonder whether it's even applicable here in this rulemaking, assuming Your Honor is considering that rule. Thank you. That's all.
Okay. Thank you, Mr. Denman. Let me get to Mr. Head now. If you could turn on your video, if you can, and unmute yourself and introduce yourself, that would be helpful, and welcome.
Thank you, Judge. I just wanted to chime in real quick on the mapping before we close that segment. Basically, I'd like to add that there needs to be some clear, concise guidance on who the appropriate regulating agency is when doing the mapping, because I've got some members in Southwest Colorado near Durango that have had issues with operators, and it's hard to get the appropriate regulating agency to decide, because with the PHMSA mega rule taking place, there's been a lot of new changes based on diameter of pipe, whether it's gathering, transmission, distribution. And if we could add some guidance in that mapping system or PDF, whatever happens, to where a landowner or anybody knows the appropriate agency to get in contact with, that would be very helpful. That's about all I got.
And I understand that makes sense, Mr. Head. So you're basically saying with the mapping functionality, that the map basically identify for certain pipelines who the regulatory agency is. That's basically
Yes,
what
sir.
you're saying. Okay.
Yes, sir.
All right. Got it. So thank you very much for that, Mr. Head. I appreciate that. So at this point, does anybody have? Actually, I have one more question regarding this proposal by CEO, and that is directed to actually public service and a statement it made in its July 27th, 2023 comments, and it's at page 12. And I'm just going to read it. Mr. Denman, what I'm looking for is just some more meat on the bone on this. So what is stated is the company, referencing public service, also notices ambiguity and a lack of clear direction in proposed rule 11100F due to a potential conflict between certain parts of 49 CFR 191 and section 42-115 subsection 1 subsection D CRS related to mapping requirements. And what I'm asking for, Mr. Denman, is just some elaboration on that potential conflict, if you can provide it.
I'm going to draw upon my subject matter experts, Your Honor, to answer that if they can help me.
So I tell you what, I probably hit all of you a little bit by surprise with this, and we are about an hour and a half in on this. So what I'd like to do is take a break, a 15-minute break. And that Mr. Denon will give you and your subject matter expert the opportunity to actually look at this and not be speaking off the tops of your heads on this. That's what I'd like to do. I only have a few other areas that I'd like to cover. So I'm not anticipating that this will go much longer, but let's go ahead and be in recess until let's say 1:25. Thank you.
Thank you, Your Honor.
right, Ms. Boulay, are you ready to go?
Ready?
And Ms. Federico?
Yes, I'm ready.
All right, give me just a moment.
Ready when you are, Your Honor.
Great, thank you. I'm just getting set up again here. Okay, we are back on the record in the third continued remote public comment hearing in 22R-0491 GPS. And where we had ended was with a question posed to public service to provide some clarification, hopefully, of a statement made in their comments submitted on July 27th, 2023, specifically at page 12. I'll turn to you, Mr. Denman.
Thank you, Your Honor. Just so the record is concise, I'll read that sentence again so that anyone who reads the transcript doesn't have to search for it. On page 12 of the July 27th comments, we said the company also notices ambiguity and lack of clear direction in proposed rule 11-100 due to a potential conflict between certain parts of 49 CFR 191 and section 40-2-115 D CRS related to mapping requirements. And this language in CEO's proposed rule includes the text and operator that's an investor in gas utility must provide in a gas infrastructure plan or is otherwise directed by the commission and map showing system-wide locations, ages, and materials or types of distribution system pipes consistent with 49 CFR 191 and section 40-2-115 D. And so the confusion starts with a statute in Senate Bill 23-291 on page 14 of the act, and this is specifically in section 40-3.2-104.4 and I'll read that. An investor-owned gas utility shall provide as part of any gas infrastructure plan or as otherwise directed by the commission a map showing system-wide locations, ages, and materials or types of gas distribution system pipes, consistent with 49 CFR 191 and section 40-2-115 D. Sounds familiar because CEO has pulled from Senate Bill 23-291 that language in their proposed rule. And however, the statute 40-2-115 was included in Senate Bill 21-108, and it requires this commission to adopt pipeline safety rules consistent with 49 CFR 191, 192, 193, and 199 to maintain minimum standards for gas pipeline safety. And one of those standards deals, and that it says in Roman D2 or D subsection D Roman 2, the Commission's gas pipeline safety rules must address and may be more stringent than required by federal standards with regards to several things. And one of them is mapping. And subsection capital C of that statute is the one that talks about the public access and limitations on the scale of publicly available images as adopted by the Oil and Gas Conservation Commission in its rule 1101.e. And here's the confusion and ambiguity. Part 191 of 49 CFR as to mapping just deals with transmission pipelines, not distribution. And moreover, it incorporates the NPMS or National Pipeline Mapping Standards Operator Manual, which is a federal mapping requirement that applies to gas transmission pipelines and requires a scale of 1 to 24,000 for publicly viewable maps. And the conflict then is whether or not the Oil and Gas Conservation Commission Rule 1101.e actually does require a publicly available map to be at the scale of 1 to 6,000. That's a statutory inconsistency, and it creates confusion for us, and that was the reason Public Service included that sentence in its comments of July 27th. I mean, it's ambiguous and there's no clear direction in there. When we first read this statute in Senate Bill 23-291 that I just cited, we didn't know what to make of it. Because it's different than what we were attempting to do in the Commission's rulemaking in this case, which is to implement Senate Bill 21-108. And we perceived a conflict and certainly vagueness and ambiguity now interjected into interpreting what does this part of Senate Bill 21-108 mean when compared to the section of paren 3 paren small a in Senate Bill 291. And so that's the reason we suggested there was some confusion and lack of clear direction.
Okay. I think I understand, Mr. Denman. Thanks for that clarification.
You're welcome.
If anybody has any reaction to that, now is the time to speak. Okay, I'm not seeing anybody raise their hands. So does anybody, I've already asked this, but I'll ask again in case anything came to mind during the break. Does anybody have any further comments regarding CEO's proposed rule 11-100 subsection F regarding mapping? I see that Matthew Van Landingham has raised a hand, so go ahead. Welcome, thanks for being here, and let me know who you're, if you are representing any entity here.
Thank you, Your Honor. I'm Matthew Van Landingham with Colorado Springs Utilities. I did have prepared statements prepared for today. However, they've already been gone over by Mr. Denman and Mr. Nolan, so I would just voice Colorado Springs Utilities support for the comments made by Mr. Denman today. Thank you, Your Honor.
Okay, thank you very much, Mr. Van Landingham. So anything further on CEO's proposed rule 11-100 subsection F? Okay, So what I'd like to do next is just go through proposals made by others in comments filed on or around July 27th. And anybody can provide any comments regarding these if they'd like. But let me start with, I have it written down as CNG has basically made a proposal for a list of information rather than a map of information. I'm just going to read from page 6 of CNG's Colorado Natural Gases July 27, 2023 comments. There, CNG proposes that rather than a map, operators provide, quote, the number of miles of pipe, including the age, type, and material by service territory, and perhaps by county, municipality, or other border designation, so long as the attributes cannot be attributed to specific locations. First of all, I think I read that right. Is somebody here from CNG? I see Angela Monroe raised a hand. Please unmute yourself and turn on your video if you can. And go ahead. Welcome.
Good afternoon. Can you hear me, Your Honor?
I can. Thank you.
Yes. So we support the comments of Excel as well, you know, to the extent that it would place an administrative burden. We support that view. However, to the extent that we have the information, we would propose that it is a safer bet to provide that information as part of just a table or some sort of list of information that would serve the purposes of whomever feels that they need that information in a way that wouldn't subject potentially the information to bad actors that could use that information for bad acts. And it was offered as a compromise solution to the extent I would say that the material is, that the information is available.
Okay, thank you, Ms. Monroe. Let me ask you this. Under CNG's proposal, would CNG, if I adopted it, would CNG be required to submit any map?
It's not that we would be opposed to submitting maps. We have concerns with the scale of the map, and we have concerns with adding the attributes to the map at any scale. So we would be fine with providing the map at a higher level at the 1 to 24,000, provided it didn't require attributes, or we would be fine with providing the list of attributes, but do not want to provide the 1 to 6,000 maps given security concerns.
Okay, so that means under any circumstances, CNG would not want to submit maps at the 1 to 6,000 scale, even if all the attributes except for location, I suppose, were not included publicly available on that map. Do I have that right?
I think so. If I understood what you said, I think so. I mean, our concern is that to the extent that you can refine that the exact location of a line is refined in a way that is publicly available, particularly that is very concerning, and we think potential for bad actors to misuse that information. We both for purposes of sort of widespread efforts to harm people, as well as just simple things like knowing, for example, if someone is being stalked, they may have someone who is interested in knowing exactly where the location of their gas pipeline is near their home. It concerns us that that level of information could potentially be used in a harmful way. And we feel that there are enough other methods for that information for the purposes that it's generally required, such as for excavations, or to work with city planners. We already have processes in place to manage those issues.
Okay. All right. So the question that arises in my mind, Ms. Monroe, is what if I conclude, as Representative Story has said, that the legislation that she sponsored requires the commission to provide a map at the 1 to 6,000 scale. What then?
Yeah, I mean, obviously, CNG will comply with whatever our legal requirements are with respect to what the commission orders. I think at that point, we would probably be taking a look at whether there were other requirements that obligated us to seek some sort of other protection or challenge the ruling. But obviously, we would comply ultimately with whatever the requirement was, even if we think that it represents a safety issue.
Okay. All right. So let me ask, does anybody have any thoughts about this? I'm sure many of you do. I'm also pretty certain that I can figure out what many of your positions would be on this. But here's your opportunity to react to CNG's proposed. And I see that Mr. Kosian has raised his hand. So welcome. Please go ahead.
Good afternoon, Your Honor. Emmanuel Koshin, representing Black Hills Colorado Gas. I also have on the line with me two representatives from our team, Brian Kretz, Director of Pipeline Safety and Compliance, and Matthew Christofferson, Manager of Regulatory, that can help answer questions as they come up. At a high level, we have a slight concern with CNG's proposal. Right now, the attributes associated with the maps are provided on an annual basis as part of the PHMSA reporting process, but it's provided at a state level. And so to provide it at a county, municipality, or a level that's heightened, a little bit more focused, there's just, I'm not sure what the ramifications are. I'm not sure how difficult that process would be. Black Hills does agree with the comments that have been provided so far by Public Service and by ATMIS as well. And I know the question came up about what's the requirement per statute. We also agree with ATMIS Energy's post-hearing comments that pursuant to 21-108, the commission rules must address mapping, which does give the commission the discretion to determine what information should be included in those mapping requirements. As expressed in CNG's comments, the commission must also balance the policy arguments provided so far in this proceeding in favor of disclosure with the requirement to protect public safety. We continue to have a concern with the consensus position, and comments were made this afternoon, or maybe this morning, regarding the state auditor report. Black Hills doesn't intend to address either the consensus position or comments made so far regarding the state auditor report, or whether the commission's pipeline safety program needs additional direction from the legislature. However, it appears that the mapping proposal is driven primarily by the need of local government to gain access to pipeline maps. And just in kind of thinking through some of the discussions so far, maybe the devil's in the details, and maybe the mapping rules should focus on the issue that the local governments are confronting or maybe confronting. Black Hills has stated previously, we work closely with the local governments in which we provide service. And I'm sure that is true of other commission regulated public utilities. And if I'm not mistaken, Public Service actually filed testimony describing their process for providing maps upon request. I would note that statute CRS 42-115 1C provides that the commission rules resulting from The implementation of Senate Bill 21108 applies to 5 different groups. It's public utilities, municipal or quasi-municipal corporations transporting or providing gas service, operators of natural gas master metered systems, operators of liquid petroleum gas distribution system, operators of pipelines transporting gas in interstate commerce, and operators of intrastate liquefied natural gas facilities. And I appreciate that just because Black Hills works with the local governments within our service territory does not mean that, as an example, operators of master metered systems are doing the same. And I think a simple resolution is for the commission to adopt a rule that applies to all 5 of those different groups, requiring them to have a process in place, provide maps upon request from either the pipeline safety program staff and from local governments. And at a high level, I think that would resolve statutory requirements that the commission rules address mapping of pipelines, resolve local governments' request for access to relevant maps in their jurisdiction, while balancing the public safety concerns that were raised by the utilities and also raised just a short while ago by Ms. Monroe.
Okay. Thank you, Mr. Cochin. I think I understand that. So I don't have any, well, I do have a question actually. So you talked about, the commission implementing the mapping requirement in Senate Bill 21-108, and you said that the commission has discretion, perhaps you said broad discretion, and I think you tied it to the statutory language directing the commission to address, the word being address, the mapping issue. And I'm speaking generally here. Do I understand that correctly? Is that the source of the discretion that the commission has in implementing the statutory requirement? Is it that statutory word?
That is correct, Your Honor.
Okay. And is that the sole source of our discretion in implementing this?
In terms of the rulemaking, our focus has been primarily on that statute. The rulemaking was derived as a result of that Senate Bill 21-108. And so the way that that individual statute reads is that the commission is required, the commission's gas pipeline rules must address mapping of all pipelines. That's the sentence that's in the statute. It goes on from there and it discusses other requirements. But in terms of the rules and this rulemaking itself, the rules must address mapping. And so what that entails is the discretion that the commission is afforded. And my understanding is Atmos Energy's reply comments discuss that same provision as well. And I believe other comments from utilities similarly discussed or provided some language along that same thought line.
Yeah, and the point that you're all making is essentially the statute does not say the commission's rules must provide for a map, must direct the commission to provide a map. It's the word address.
Correct.
With respect to the mapping issue. Okay, I got it.
And I think with a slight caveat that, and Atmos Energy's comments kind of discussed it, or reply comments discussed it a little better. So Mr. Stoffel may have to jump on and assist here, that the discretion is in terms of what is required in terms of maps, but once the map is provided, it's the last sentence in subpart C that the mapping requirements for pipelines must incorporate the standards of confidentiality, security as laid out in subpart C. And so that's part of the concern that the utility has, that once, if the commission orders the utilities in Black Hills to provide copies of all its maps to the commission, provide those to the pipeline safety program staff, that it's difficult at that point for the commission to say, oh, but we're only going to disclose parts of those maps as part of that subpart C.
So why would that be difficult for the commission? In other words, why couldn't we require all operators to provide all of that information, but then only make publicly available a subset of that information?
I think pursuant to statute, the subset of information that the commission can allow or release is kind of described in the statute itself. And we've kind of walked through it in our comments filed so far, in previous comments during the rulemaking hearings to date, that Black Hills is very sensitive to cybersecurity issues. We're very sensitive to vandalism.
Understood.
It doesn't take much to, once the information is released, there is no pulling it back. And this type of sensitive information is not something that should be out in public view.
Understood. Thank you, Mr. Cushion. All right. Any other comments, reactions regarding CNG's proposal? And again, that proposal is essentially to provide, as I'm characterizing it, a list rather than a map containing the type of information that we've all been talking about. So I see Ms. Lowry was the first one up. So go ahead, Ms. Lowry.
Thank you, Your Honor. CEO doesn't support CNG's proposal as an alternative because we don't think it complies with statute or would provide the information that CEO and the other parties need in the gas infrastructure and clean heat plan. Thank you.
Thank you. And Mr. Nygren, or not Mr. Nygren, Mr. Sura, I believe, raised his hand. So why don't you go ahead?
Thank you, Matt Sura, representing Mark and Julie Nygren.
And welcome.
Thank you. Senate Bill 21108 does not give the PUC discretion on this issue, not for the scale or the pipeline attributes that need to be made public. The discretion that you have and the PUC has is in the implementation date. If you take these arguments at face value and believe that it is a dire threat that this information becomes public, then you could put that implementation date out until after the legislative session in 2024, because they're the ones that have to, solve this problem. If indeed you believe that it is a problem in the position of the Nygrens and many of the local governments that signed on to the consensus position, is they don't see it as a problem. But if you take it as a problem, then that is your solution. Give the operators an opportunity to try to fix it through the legislature. Thank you.
Thank you, Mr. Sura. I appreciate that. Okay, Mr. Denman, why don't you go ahead?
Thank you, Your Honor. If you're inclined to consider including CEO's proposed rule to remain in this gas pipeline safety rulemaking, CNG's language is an alternative we would consider, but we think it needs some more work in order to address the issues that we've raised. So firstly, we stay with our position that we've submitted in written comments and oral comments. A couple of the issues that we have that are not solved by CNG's compromise proposal is that we submit to PHMSA in an annual report mileage by material of pipe and mileage by decade of installation, as much as we know. The suggestion that they have that this information be included by service territory and perhaps by county, municipality, or other border designation is unclear to us. And we believe that that system boundary designation is too open-ended For example, if the system boundary is too narrowly defined, then it's possible that we would have to submit a lot of different submissions for maps that are in a more granular form, instead of defining the system more broadly so that you do one map and not 100. But our basic position is we stay with our original position that if you're considering the CEO's alternative, there could be some room to work with CNG's proposed language. Thank you.
Okay, thank you, Mr. Denman. Natasha Ledger just raised a hand, so why don't you go ahead? And again, I apologize if I've butchered your last name. Is it Leger?
It is Leger, Natasha Leger with Citizens for a Healthy Community. Thank you, Your Honor.
Thank you.
I just wanted to say that I support Matt Sura's comments, and that the statute is unambiguous in requiring a map and not a list of information.
Got it. Thank you very much. Okay, anybody else have any thoughts on CNG's proposal? Not seeing anybody pop up, so let me move on. Second to last issue that I want to address, and it has to do with the discretion issue. And I think I just had the colloquy with Mr. Kosium about the source of the commission's alleged broad discretion in implementing the map requirements in the recent legislation. Does anybody have any thoughts on how much discretion, if at all, the commission has in implementing Senate Bill 21-108? Mr. Denman, go ahead.
Your Honor, with all due respect to those who think this statute is clear and unambiguous, we don't agree. I believe that when you examine the statute, and particularly when you look at the confusion that's been interjected by Senate Bill 23-291, which I talked about a few minutes ago, and you look at the case law on the commission's authority under Article 25 to regulate utilities and their facilities, you can discern a finding that the statute is not clear and unambiguous. And so then, if it is not, you can resort to the usual rules of statutory construction to interpret that statute and interpret the extent of the commission's powers. I believe that Black Hills and Atmos made a cogent and reasonable argument about the fact that the commission has the discretion to interpret its organic legislation, including Senate Bill 21-108, in order to fashion fair, non-discriminatory, and legal rules here in this rulemaking. Thank you.
Thank you, Mr. Denman. Okay, so with that, I'm going to move on to the last issue that I want to give everybody the opportunity to provide comment on, and that is the proposal by Public Service. I'll call it an alternative proposal in their latest round of comments. And I don't have a specific page site, but this is late in their most recent comments. And I'm just going to read it. Public Service, quote, alternatively proposes that the parties provide for two separate scales. Number one, displaying transmission pipelines at a scale of 1 to 24,000, consistent with the PHMSA National Pipeline Mapping System. And two, a scale of 1 to 6,000 for distribution and gathering pipelines. At either scale, the data should be limited to no more than the designation of the pipelines as transmission, distribution, and gathering pipelines, along with location of pipelines, the operator, and commodity as shown below. And then down below, public service stated, if however, a rule establishes a scale at a 1 to 6,000 level for all pipelines within the commission's jurisdiction, then only the location, operator, and commodity data should be provided for displayed pipelines. At a 1 to 6,000 scale, the company recommends that designation of pipelines as transmission, distribution, or gathering pipelines should be removed from rule language due to concerns related to bad actors identifying transmission pipelines, end quote. Like I said, I don't have a specific site for that, but it's late in, it's within the last 2 to 3 pages, I believe, of Public Service's most recent comments. So I wanted to give everybody the opportunity to weigh in on Public Service's proposal that I just read to you. Ms. Monroe has just raised her hand, so why don't you go ahead, Ms. Monroe, again, welcome.
Thank you, Your Honor. As I noted earlier, we of course have concerns about transmission lines, but our concerns are not limited to the larger transmission lines, as we're concerned that there could be much smaller lines that would run by locations that could be very devastating if a bad actor were to try to take advantage of that information. So we feel that even though transmission lines might be a target for some bad actors, it is likely not the only target that bad actors would pursue. So our concerns are also related to distribution lines.
Okay, so and with respect to Public Services proposal, I mean, part of it is if the commission is going to provide a publicly available 1 to 6,000 scale map, I believe Public Service is saying, you know, you can obviously, I guess, show location, operator, and commodity data, but not designation of transmission, distribution, or gathering. Does CNG support that or not? Perhaps I didn't completely understand what you were saying previously.
To the extent that they're suggesting that we would provide a map that would be down to the 1 to 6,000 level, that would show the location of the facilities, which I interpret them to be suggesting would be okay for distribution. We have a concern with that. Yes, we are concerned with giving that level of precise information about the location of pipelines in a public format.
Okay, so you've probably said this previously, but this is a big record, so I don't remember for sure. So let me ask you, if I conclude that the commission has to, and the commission agrees with me, the commission has to provide a publicly available map at the 1 to 6,000 scale, what information would CNG support, if any, being on such a map?
We would not support a map at that level to be publicly available.
Got it. Okay, thank you, Ms. Monroe. That made it really clear. So I appreciate it. Does anybody else have any comments that they'd like to provide regarding Public Services proposal? Mr. Stoffel has raised his hand, so please go ahead and welcome again.
Thank you. I think Public Services proposal is consistent with the discretion that we've been advocating that you have, and consistent with the discussion you just had with Ms. Monroe. If you found that you are required to impose a mapping requirement for all pipelines under the commission's jurisdiction, we think you have the discretion regarding the information shown on that map. And Piesco's proposal is consistent with exercising that discretion to both provide public access to the map and limit the disclosure of the information regarding the pipeline shown on that map.
Okay. I think I understand, Mr. Stoffel, so thank you for that. Anybody else want to provide any comments regarding public services proposal? All right, I'm not seeing anybody pop up with the hand or otherwise. So I will take that as a no. So that is the end of the issues that I wanted to cover today. Does anybody have anything else that they'd like to say that's relevant to this rulemaking? And I think that's Ms. Nygren, that's who I'm seeing. Hello and welcome. Is that Mr. Nygren as well?
Yes,
Mr. Nygren's here also.
Mr.
Okay.
and Mrs. Both here,
Thank you.
Farley, and thank you for allowing us to participate in this hearing. Again, my name is Julie Nygren from Nygren Family Farms. We live in Johnstown, Colorado. As a family that has been personally impacted by the lack of pipeline regulations, this rulemaking process has been frustrating. When our home was contaminated and then demolished by a pipeline operator, Phillips 66, it was clear that we were completely on our own. There was no state agency we could depend on to watch over the operator, the pipeline, or to conduct any investigation over the leak. In reading the rules in detail, it's become even more clear how far our state needs to go to prevent pipeline explosions and leaks from harming another Colorado family. Senate Bill 21-108 was passed more than 2 years ago, but the required rules for pipeline mapping and advanced leak detection still have not been adopted. The industry's response during this rulemaking has been to give the public less pipeline information than required by law and to further delay advanced leak detection requirements. We ask the opposite. Please follow Bill 21-108 and require pipeline mapping to 1 to 6,000 scale and require advanced leak detection programs for every pipeline operator in the state. The state audit has placed a spotlight on our broken pipeline safety program. From 2017 to 2022, more than 50 pipeline safety incidents were not reported by industry. The threshold for an incident is frankly ridiculous. It is that someone must die, be hospitalized, or there has to be more than $122,000 worth of property damage, or more than 3 million cubic feet of methane released. The audit claimed to have learned about these incidents not from the PUC pipeline safety program, but from the media. There are likely far more than 50 incidents that were not reported. In another state, this would be called a cover-up, but pipeline operators in Colorado have no need to hide anything. Pipeline operators don't have to worry, even if they do not report their leaks and accidents. Even when pipeline incidents were reported, there was little or no investigation and little to no enforcement when our weak pipeline safety rules were broken. The industry has nothing to fear in Colorado except the possibility for bad publicity if an explosion is noticed by the media. With no enforcement or consequences, pipeline operators are allowed to conduct their business as usual. Along with pipeline mapping and advanced leak detection programs, our final request is to require every leak discovered to be reported annually. Requiring the reporting of every leak is a necessary step for the public to regain trust in the industry and in this agency. My testimony today is my own. However, I want to thank the more than 20 local governments and organizations that have supported our written comments and redlined rules. The support we have received from numerous local governments, organizations and elected officials like Representative Tammy Story gives us hope that Colorado will someday have an agency and regulations that will protect Colorado residents from avoidable pipeline safety accidents. Delaying The implementation of these rules and regulations puts people like myself and my family, as well as the general public, at risk. Please adopt our proposed red line rules. Thank you.
Thank you.
Thank you to both of you for participating in this and for the very informative and helpful comments that you provided working with Mr. Sura. I appreciate it, and I'm sure the commissioners at the commission will appreciate it when, as I anticipate, they have to rule on exceptions to the recommended decision that I will write. So thanks to both of you. I hope things go on an upward trajectory for you. And thanks again.
Thank you.
Thank you.
Your Honor, if you wouldn't mind, could I just ask a question to follow up on that last comment you made?
Yes.
Matt Sura again, representing Mark and Julie Nygren. From your comments and from the discussion at the PUC work session yesterday, I understand that the requirements for advanced leak detection programs is going to be punted to a separate rulemaking. And we certainly hope that that is done as soon as possible and hopefully before the next legislative session. But the other two issues that were raised in the comments and in the consensus position were that this issue of pipeline scale, and we've gone through that in exhaustively today, but also
do you mean the mapping scale?
Yeah.
Okay.
Yeah. And also annual reporting of all leaks. That is not an issue that it sounded like was going to be the subject of the upcoming rulemaking. And so we ask and hope that you will consider including that as part of the proposal going forward to the PUC. There has even been some support, albeit some tepid support by industry, and the idea of annually reporting all leaks to the Public Utilities Commission. It will help the Public Utilities Commission know where they can focus their resources and identify both the pipelines and operators that need the more inspections, and will generally help the public understand that there's going to be some transparency and that all pipeline leaks will be addressed eventually.
Thank you. And to the extent that was a question, I'll tell you that my intent, let me just tell everybody, we're going to conclude the public comment hearing today. That will conclude all the public comment hearings. And then, I have to submit a recommended decision. So I'm going to have to review the entire record in this proceeding, which is pretty well voluminous at this point, and then write a detailed recommended decision to the commissioners about what to do with respect to the proposed rules and the various counter proposals that are made, including those by you, Mr. Sir, on behalf of the Nygrens. And then I write a recommended decision about what to do. Everybody will have the opportunity to file exceptions to my recommended decision, meaning you get to tell the three commissioners exactly how I got it wrong, what I got wrong, and how I got it wrong, in an attempt to persuade the commissioners to go in a different direction than I did. So I've got a fairly big writing process, review of record and writing process ahead of me. My plan is to include the map scale issue and the reporting issue in what I'm recommending to the commissioners. I can't tell you at this point what the outcome is going to be, but my plan currently is that those two issues will be addressed in my recommended decision, and I'll have rule language that addresses both of those issues. I guess I would quibble slightly with your language about punting the advanced leak detection technology issue. You know, as Dr. Fischhaber said in yesterday's weekly meeting, an awful lot has happened since the notice of proposed rulemaking came out. This is a pretty new area, and it's a fastly moving area. So my interpretation of what Dr. Fischhaber said was essentially the commission wants to make as informed a decision as possible on the advanced leak detection technology issue. And, you know, engaging in a, you know, relatively quick stakeholder process, and then implementing a notice of proposed rulemaking on that issue, and perhaps others, I'm not sure, is the best way of doing that. So anyway, that's my understanding about what's going to happen, and my expectation about what my recommended decision will include. So to the extent there was any ambiguity or lack of clarity about that, I hope that helps.
Thank you so much, Your Honor.
Thank you, Mr. Sura. Let me move to, you've been very patient, Ms. Leithwood. Did I get that right? I apologize if I
yes,
didn't.
that's correct. Thank you. And thank you so much, Judge Farley, for taking public comment today. I'm Heidi Leithwood, Climate Policy Analyst for 350 Colorado. 350 Colorado is a grassroots organization with 20,000 members statewide, working to address the root causes of the climate crisis while prioritizing environmental justice. We support the rule red line as proposed by the Nigrans. And I just want to take a brief moment and extend my deepest sympathies for their experience and to thank them for their courage and commitment in coming forward with this rule proposal. Methane is incredibly dangerous. It's a direct safety issue. Large leaks are well known to cause explosions. It can also directly damage property and health, and the Nigrans experience is a prime example. We must also consider indirect health impacts. Methane is an ozone precursor. This fact is not talked about much. NOx and VOCs are the more well-known ozone precursors, but methane also leads to the formation of ground level ozone. And I'm sure you're aware that the Denver Metro and North Front Range area has been out of attainment for ozone NACs for over 15 years. Better detection and repair of all leaks could have a huge impact on this problem. Of course, methane is also a powerful greenhouse gas, 86 times more powerful than carbon dioxide over a 20-year time frame. SB 21-108, which mandates this rulemaking, intends to protect public health and the environment from methane leaks from pipelines. It specifically mentions climate change as one of the impacts this rulemaking should address. Immediate reductions in methane emissions will have near-term impacts on warming and could avert warming up to a half a degree. That half degree could save hundreds of millions, if not billions, of lives globally. Colorado law requires us to take steps in line with global efforts to contain warming to 1.5 degrees. And Colorado has set out emissions reduction targets. Laws and rules to reach these targets are reliant on reported emissions, which are usually from calculations and projections. Leaks, large and small, add up to the reality that our real methane emissions are far larger than our reported emissions, but we don't yet know how much larger. The trouble is, without accurate information about how much methane is being emitted, and without addressing leaks, which fall outside of the current calculations used for our inventories, the laws and rules designed to reduce emissions to mitigate global warming are merely paper-pushing exercises. The AQCC just passed rules designed to verify emissions from the upstream oil and gas sector. Emissions from the pipelines under the jurisdiction of the PUC should also be quantified. The PUC has the power to enable Colorado to find out more about how much methane these leaking pipes are contributing to global warming. Reporting only major leaks will not do it. Every leak should be reported, quantified, and reported to the PUC, also shared with the APCD, so it will be included in the inventory. Also, leaks should be required to be repaired immediately or as close to immediately as possible. Any argument against this that puts industry cost ahead of public health is unethical. Allowing industry to put off repairing leaks means we're allowing them to put the costs of doing business onto the public in the form of health damages, lost property, and the impacts of climate change, which is already costing Colorado billions and impacting our agriculture and public recreation industry. Back to the direct effects. We can see from the Nigrins case how damaging a small, slow leak can be. If just one family can be spared that by the Nigrins' proposed rules, it will be worth it. It would have been illegal for a DCP to enter the Nigrins' property and dump a poisonous gas, destroying their property in hell. The law should also protect people from company policy of failing to detect and or putting off the repair of leaking pipelines. On behalf of our 20,000 members, I urge the PUC to pass the rules proposed by the Nigrins. Thank you again for taking my comment today.
Thank you very much, Ms. Leafwood. I appreciate your comments and your participation in this proceeding. It's been helpful. So let me turn next to first name Laura, who has a hand up.
Thank you so much, and I apologize for not having my last name on. My name is Laura Bloom. I'm with Western Colorado Alliance, and I wanted to thank you so much for taking the time to listen and consider all of these viewpoints. It's very important to have a contextual understanding in addition to all of the fancy words that get thrown around in these spaces. So I appreciate that. I wanted to extend the Alliance's full support for the red lines that the Nigrin and Mr. Soda have put forward. While I understand that there are security concerns, I do think that we also need to prioritize the health and well-being of all of the residents within Colorado. This does include making the consideration of valuing the lives of people as much as we value the money that we put through these pipelines. Thank you very much.
Thank you very much, Ms. Bloom. Appreciate your comments. Would anybody else like to make any comments about anything relevant to this rulemaking? I'm not seeing anybody. Oh, there's one more. Ms. Leger, please go ahead.
Thank you so much. I just wanted to conclude by saying this is a real opportunity for the PUC to strengthen its pipeline safety regulations and really encourage you to do so. And according to how Senate Bill 22R-0491GPS outlined how the PUC in its rules are to address mapping of pipeline information. We fundamentally disagree with the interpretation or tortured interpretation of the statute of discretion, because it's clear that the statute states the requirements for mapping at 1 to 6,000 along with the line attributes for mapping pipelines. And so we also wanted to mention the importance on reporting requirements, that they apply to all pipelines. We heard about that applying to all leaks, and just want to be clear that that's all pipelines, including type R pipelines. And with that said, I want to close and appreciate the time for comments today, and again, urge the PUC to take action that goes above and beyond the federal minimum federal standards.
Okay, thank you very much, Ms. Leger. I understand and I appreciate your comments.
Thank you.
Anybody else want to provide final comments? Okay, I'm not seeing anybody else pop up. So with that, let me thank all of you for participating in this rulemaking. I appreciate it very much. And as I said, I'm sure the commissioners do and will as well. This is a very, this is a robust record. There are lots of complicated and very important issues, which is reflect the number of you who've been participating in this rulemaking. Again, I'm very thankful for your participation because it's helped me to better understand all the positions that have been presented regarding these rules. I've already explained the process that I'm going to go through, and that's what's going to happen next after I adjourn the public comment hearings. But just to reiterate, I'm going to review the record and write a recommended decision. It's going to be a recommended decision because you all will have the opportunity to file exceptions contesting any decision that I've made. Your exceptions will go before the 3 commissioners of the Public Utilities Commission, and they'll have the opportunity to decide that. So obviously, keep well in mind the period within which to file exceptions, and don't file them late. And that period is spelled out in our rules of procedure, the Commission's rules of procedure. So with that, let me just thank you all again, and give me just one moment. Yes, so let me just reiterate my thanks and wish you all well. And this public comment hearing is adjourned. Thank you.
Thank you, Your Honor.
Thanks, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.